Welcome everyone. So this session is on service charges in GP premises. Just to give a bit of background, so we did a session on GP leases generally around a year ago, and the majority of the questions that we got were around service charges. So we thought we'd do a session to cover just service charges because there's so much in it. So today we're going to cover introduce ourselves first. So I'm Clare Good. I'm a senior associate in the disputes team at BMA Law and deal particularly with property disputes. I've got Stephen Meade with me, who's a partner in the team, and Kai O'Kane, who's a solicitor in the team. In this session, the screen shows what we're going to cover. You'll hear us mention NHSPS, PropCo quite a lot and CHP, but that's because that's the majority of the questions that we get at BMA Law and the matters that we get involved in. But it does apply generally to other landlords, and we know there are other landlords out there. So when we're saying NHSPS, we're referring to the landlord, and those principles will still apply to your situation. So the first topic. So just to give a bit of an overview before we get into the details, what service charges are. I'm sure you know, but there's just a general definition up there on the screen. So in summary, service charges arise when a landlord has provided services to the tenant at a property, and there is a right for the landlord to recharge those, so the costs of providing those to the tenant. The scope of what services are provided and what services are recharged will come down to the specific terms of each tenancy, which we'll talk about today. But generally, the kind of services you will see are for maintaining the premises, repairing the premises, renewing it and running it. So including things like security or reception staff. That's the kind of things that will be included in a service charge if there is the right if you have to pay one. We did have one question beforehand, which was whether specifically building insurance is a kind of norm for a tenant to pay a landlord. As we'll discuss in this webinar, what a landlord can charge for, if anything, in the service charge will come down to what exactly has been agreed, whether it's written or what can be implied from conduct if it's unwritten. So each item, it will come down to what the terms of the tenancy are. You do often find in a strictly commercial setting that the building insurance for the premises is something that a landlord can recover, and it's quite often a separate term in written leases. But it does, as I say, come down to the terms of the tenancy, and even if there is provision to pay, really the landlord should be looking at kind of cheap, not the cheapest insurance, but not, just going out and getting any insurance before they recharge it. So often you'll see a service charge will arise where the landlord has a positive obligation to provide services, and in doing that there's a corresponding obligation for the tenant to pay for them. Sometimes it also arise where there's not a positive obligation, but if a landlord does provide a service, they can then recharge, but it's quite often where it's actually an obligation on the landlord to provide those services. Next, previous slide. Go back to that one now. So does every lease include a service charge provision? No, in short. Leases can also place repairing and maintenance obligations on the tenant instead of a service charge. So in that scenario, the obligation would be on you as tenant to actually keep the premises in repair instead of the landlord doing it. And then if you fail to do that, you'd potentially have a dilapidations claim at the end of it. Service charges are where the landlord is, where there is no obligation on the tenant to actually do those services. Additionally, some leases may place an obligation on the landlord to actually provide services, or the landlord may choose to provide services, but there isn't a corresponding right to recharge. For example, there might be an obligation for it to undertake kind of more capital expenditure works that are more to do with the fabric of the building, but there isn't a right to recharge. So again, it will come down to exactly what's been agreed. Just put up on the screen the kind of 4 main bases of occupation that you might be in place for you. There are different bases. Potentially service charges can arise in all 4 of those, but we see it come up most often in a unwritten tenancy or a written lease. It doesn't come up as often in a tenancy at will or a license because they're seen as more, they're not seen as long term. So today we'll focus on written and unwritten. Next slide, please, and then the next one. So firstly, we'll look at the situation where you've got an unwritten lease. So the starting point is that by their very nature, it's very difficult to decide or to decipher what the terms are when it comes to an unwritten tenancy, because there isn't a written lease there. There's nothing to refer to when the landlord is making a claim for service charges, or when the tenant is requesting services or refusing to pay. So the starting point is to look at the conduct of the parties, to look at what's happened over time, to look at any documents that exist from the beginning of the tenancy. In some cases, we find there's a very helpful paper trail. So, for example, negotiations that took place prior to the practice taking occupation, quite often there might be heads of terms or even draft leases that have been exchanged between you and the landlord, or between the solicitors, that will show where you got to in agreement, even if you didn't actually execute those documents and enter into them. If the parties are generally happy with them, or the parties know that's the basis on which you'll take occupation, then quite often that is a very helpful tool to be able to decipher what obligations are on you and what obligations are on the landlord. Still open to argument, but it is a very useful paper trail. Other helpful documents that might help you determine what the terms of your tenancy are would be invoices that have been issued from the outset of the tenancy, any breakdowns of service charges raised, and disputes on those, or refusal to pay, and credit notes that have then been issued, and evidence of any works a landlord has undertaken but not recharged, or undertaken and recharged. That will help you to kind of carve out what a landlord has agreed to take on as an obligation without a right to recharge, and what they've agreed to take on with the right to recharge. Where there aren't any documents at all, or aren't documents that exist, or there's no partner that was available at the time, things are a lot trickier then. So in the 5 cases that the BMA supported, 3 of those practices didn't have a written tenancy. So whilst they weren't test cases, and every situation has to be looked at on its own facts, the judgment did provide a lot of helpful guidance for people who are occupying without a written lease. So Stephen's going to run through the key comments from the judge there.
Afternoon, everybody. Thanks, Claire. So as Claire mentioned, in the Valley View case, there were 2 practices actually that had an unwritten tenancy. So there was quite a lot of uncertainty about what the terms of the service charge provisions were. And there was a lot of debate between, in this case, NHS PS as the landlord and each of the tenants leading up to the litigation itself. And there was no meeting of minds. So ultimately this ended up in trial. So the two GP practices in this case with unwritten leases were asserting that the different terms of what the service charge provisions are. It was common ground that these practices occupied their premises under the terms of tenancies, which were implied by conduct because there was nothing written down. One of the practices claimed to have an annual cap on the overall amount of service charges. So they said each year we don't pay more than X. And the other practice was claiming that the service charges were included in a global rent payment. So they were saying there was only one payment they had to make, and that was pretty much fixed. And in terms of rent, they didn't have to make any further payments on top in relation to service charges. The practices also claim that the landlord, NHSPS in this instance, is obliged to continue to provide the services as it has done to date, so to carry on providing those services as they've historically received. In putting their claim forward to NHSPS and ultimately to the court, the practices relied heavily on how service charges had been dealt with previously by their landlord previously, and in the main that was the primary care trust. And the practice claimed that the conduct of them, the practice and the predecessing partners, and also of the previous landlord, was evidence of, one, the cap on the charges and service charges, and also the global rent figure. Ultimately, the court disagreed with both the practices in relation to what they put forward, and they found that the practices had agreed to pay the landlord's reasonable costs of services which were reasonably provided. That doesn't give a whole lot of certainty, and I'll come on to that in a moment. The way the court approached the issue, the core issue in these 2 cases in relation to what the service charge provisions are, was where a party occupies premises without having agreed terms, so there's no written terms. It said the law will imply from what was agreed and all the surrounding circumstances, the terms that the parties are to be taken not have intended to apply. So it does boil down to what the intention of the parties are that are coming together in this contract, which is a lease, even though it's an unwritten contract. The judge made it clear in his judgment that it's not enough for the practices to rely on how the practices grew accustomed to the status quo with the PCTs. There was a lot of evidence put before the court in relation to these two practices and also other practices that the PCTs had agreed to deal with service charges in a way which was that they didn't recover the full costs of what the services cost them to provide. And there was evidence of that in relation to charges that had been levied over numerous years and invoices and other documentary evidence as well. But the judge found that the PCTs may have dealt with service charges in a fairly haphazard and inconsistent manner, but it held that that did not mean that the PCT paid any particular thought to what they were doing, or that it intended in a legal sense to meet the shortfall in the costs of the services it provided, and the shortfall about the amounts that it recharged the practices in each case. So it found there was a lack of intent of the parties when reaching their agreement for the lease, and that's a core element of a contract between two parties. There has to be a mutual intention to what's agreed between the parties. And if that's not known expressly, as it would be in a written document, in a written lease, then that has to be deduced through evidence. And the court found that just because the PCT acted in a particular way and the practice acted in a particular way, although they gave circumstantial evidence, that did not give proof sufficient on the balance probabilities to prove that those are the tenancy. So given those findings by the court, and there's fairly little other legal precedent on unwritten leases for service charges and deducing what those terms are, but given those findings, the practices will need to be able to refer to specific evidence of what has been agreed and what was consciously intended by the landlord and the tenant at the time they entered into the lease. And in those circumstances, practices should be able to establish what the agreed and binding terms of their occupation are. Just moving on to the next bullet point line covering, which on the slides there, which is the practices should put their case forward to the landlord on service charge terms. The guidance in the BMA has always been that the practices should continue to pay the amount they agree is payable and not pay anything which they dispute. However, the judge made it clear that it expected the practices to go further than this and to put its case to its landlord, in that case NHS Property Services, on what it says is payable and why it says it's payable. The judge made the comment that actually practices may be in actually a better situation, if not the same situation as NHS Property Services, to be able to provide relevant information, documentation to try and piece together what the parties actually intended at the outset. So the court was saying the GP practices should not sit on their hands and just wait for NHS Property Services to come and prove their case. But that's not to say that practices have to do all the running. It was expecting there to be a two-way dialogue of sharing the information and one side putting their case to the other to hopefully reach a landing on what actually the parties intended by reference to all those documents. I'll hand across to Claire now, who's going to move on to the next items.
So the remainder of this slide just covers some of the kind of most common questions that we get from people who have got unwritten leases. And I should have flagged at the beginning, there is a questions box. If you have any questions as we're going along, put them in there. Hopefully we'll have some time at the end to cover them. If not, we'll be able to contact you, or our contact details will be at the end. So the first one there is, if I agree there's an implied term to pay service charges, does that mean I have to pay everything? In short, no. Often I think there's been a reluctance to agree that there's any obligation to pay anything, because the fear is then that you'll have to pay every penny that the landlord is demanding from you. in particular when it's NHSPS, and those figures are so much higher than they were from before when you pay in the PCT or your previous landlord. So again, it is going to come down to the precise terms of the tenancy, which again, as we've explained, is difficult to decipher, but it may be that you've got evidence that certain things are excluded from that. So as I mentioned before, there may be specific elements that cannot be recharged from the landlord. For example, if there's improvement works to the fabric of the building that aren't really a service that you need, it's not repairing, it's not maintaining, it's the landlord doing something it's decided to do to kind of increase the value of its asset. Capital expenditure works, as I say, such as replacing a roof, things like that, you may be able to argue there isn't an obligation on you to pay that, especially if you've not been in there for a long time or it's not intended for you to be in there in a long time. Even if there's an obligation to pay for the services being provided, those services usually should be reasonably provided and at a reasonable cost. If you don't think that the services are actually being provided, if you see items in your schedule that you don't think that you get the benefit of, or that they're unnecessary, they're being provided but you don't need them, or you haven't asked for them, or the service is poor, or it's too expensive, then those arguments can be raised to bring down the cost of that, even if there is a positive obligation on you to pay them. So, for example, if you think that the costs of cleaning are far too high and you've got comparables, then you can show that to say this is not a reasonable cost and it's not a reasonable service. Try and reduce the amount that you pay. Often people try to put caps in place, but that can be very difficult to agree. In the 5 cases that we had when we put NHSPS to proof on the kind of item by item of what they were charging for over the years, they simply couldn't evidence every penny in there, which is not uncommon, but they couldn't evidence a lot of it. So they had to replead their claims, significantly reducing the amount they were claiming in 3 out of 5 of them, because they couldn't find evidence of a lot of what they were charging. In the end, the quantum part of the case settled, so we didn't get a judgment on the kind of technical points around the evidence they were providing, but those settlements achieved were reductions of between 80% and 80 and 12%, I think over 350,000 in one case. So if you do have concerns over the figures that are being charged to you and other things on the service charge statement you don't understand or you don't think are necessary, then it's certainly worth raising those arguments with your landlord. The final point on unwritten leases is whether, do I have to sign a written lease? This is a very common question because I think practitioners understand, everybody understands that it is difficult to continue to occupy without written terms, and a lot of the disputes arise because there just isn't any written terms. No one really knows where they stand. On the face of it, no, you don't have to sign a written lease. The only caveat to that is that if you get served with a Section 25 notice, that's a statutory way for your landlord to force you to enter into a written lease. That is severe consequences if you don't deal with that or you ignore it, because potentially at the deadline in there, your landlord may take possession of the property if you haven't entered into lease or done one of a number of other things. So it's worth, if you do see something that says Section 25 on it, is worth getting legal advice very quickly because you'll want to deal with that. Even if you're not served with that and your landlord is not trying to force you to enter into a written lease, you might see the benefit of entering into one anyway, because it will clearly set out the rights and obligations of the party. There's a chance to negotiate the terms of a lease then, so to try and put forward the kind of information you're going to want in a service charge going forward. And in theory, it means there's less scope for dispute going forward. However, I'll pass you over to Kai now, who's going to discuss written leases and the kind of disputes we see with those.
Thank you, Claire. As Claire said at the start, I'm going to be speaking about the position of service charges when it comes to practice who have a written lease in place with NHSPS or any other landlord. Now, when a practice does come to us with a written lease, it's often the case that our initial thought is great, everything must be incorporated into the lease, and NHSPS or the landlord will be basing their service charge demands on the terms of that lease specifically. However, as we will see and as I go on, that very often turns out not to be the case. I'll be labouring this point quite a bit as I go through my discussion on written leases. But when a practice is in occupation on the basis of a written lease, the starting point always has to be, unsurprisingly, the specific terms contained within that lease. In this regard, NHSPS at trial did set out what their process was in respect of practices with written leases, in that, firstly, if the asset managers, having looked at the relevant lease, did not see anything in it which would contravene or contradict the terms of the charging policies, then they would simply say nothing. And in that case, the property management accountants would go ahead and work out what was then owed by the tenant. Alternatively, if the asset management department found that something in the leases contradicted the terms of the charging policies, they would then tell the practice management accountants that they had to deviate from the policy in line with the specific terms of the leases. In this regard, Mark Smith, the CFO of NHSPS, stated at trial that the charging policies always come secondary to whatever the contractual basis of the agreement is with each occupier. Now, that per the evidence that was put before the court, we've seen a number of instances where that was actually deviated from. It was made clear that irrespective of what the actual lease position was, NHSPS were in fact raising service charges on the basis of the charging policy. For example, in the case of St Andrews, it was confirmed by an NHSPS witness at trial that they had simply applied the terms of the charging policy without ever having read the specific terms of the lease that was in place. One step further again, and one of NHSPS's witnesses who was responsible for the management of the Bushbury practice confirmed that they had begun raising service charges on the basis of the charging policy when it was introduced in April 2014, but was unaware that there was a written lease in place between the practice until the very day before trial. So it just goes to show that these instances do arise, and it's very important, and I will labour this point, to always revert back to the written terms contained within the lease. Although NHSPS's position, or any landlord's position for that matter, may well be that they will consider the terms of the lease against any charging policy that may be in place, that's obviously quite a difficult task to undertake when you're unaware that a lease exists in the first place, or simply haven't read the terms of that lease. Apologies. So in relation to interpretation of particular clauses, if you are practiced with a written lease, again, our first port of call would be to encourage you to raise the terms of your lease with NHSPS, as well as its existence in a number of cases, and make sure that the asset management team there has a copy of the lease and has updated its internal system to confirm that they should only be charging on the basis of the lease and not that of the charging policy. It's also really important to set out your position as to the interpretation of the specific service charge clauses contained within your lease. For example, in the case of Bushbury, the written lease provided that the tenant was obliged to pay, I'll just read this verbatim, the apportioned cost of services supplied to the premises, including gas, electricity and water, such costs to be reasonably determined by the landlord. Now, the parties before this matter went to trial were in agreement that this clause requires the tenant to pay for a wide variety of service. The important part here being that although items such as gas and water might have been expressly included in the service charge clause, it doesn't automatically follow that this is an exhaustive list. Notwithstanding this, however, the basis for demanding service charge payments must always derive from the terms of the lease itself. And also, even further again, if the wording is contained, must take note of the reasonable reference contained within the clause. There were similar wide definition of service charge clauses contained within the lease in the St Andrews claim. Apologies. In that the definition of the service charge was a fair proportion to be determined by the landlord's surveyor acting reasonably of the cost and expense of maintaining and, as necessary, repairing, building, redecorating and renewing and cleansing. Again, in this respect, the judge made it clear that irrespective of what is being charged for, the basis for demanding the service charges must derive from the wording of the lease and not the charging policy. So in terms of seeking to challenge the demanded service charges, in a lot of times, in a lot of instances we've come across, it's really not uncommon for a lease to contain alternative dispute resolution clauses, which set out that disputes relating to service charges or anything else for that matter ought to be dealt with or need to be dealt with by way of arbitration, for example, or another avenue. Similarly, there may also be, further alternative avenues and strict processes that the parties must undertake in terms of engaging in any form of dispute. again, it's worth considering this going forward in terms of any issues you seek to raise with NHSPS or your landlord. But it's also really important to consider these clauses in full to ensure that any form of communications that are coming from NHSPS, including in respect of any threatened legal actions or proceedings, that they are in line with the parties' obligations to arbitrate disputes under the lease. And then also it's worth considering when seeking to raise challenges with NHSPS, whether the lease provides any specific mechanisms on how or when the service charges can be demanded. I'll keep labouring this point and I keep returning to it, but the first port of call will always be to return to the strict wording of the lease. Sorry, just next slide there. Yeah. No, sorry. That's right. So if you consider that NHSPS have not adhered to such provisions in terms of the specific mechanisms on when the service charges can be demanded and what they can demand for, we will always advise to set this out in writing to them, as well as asking for their position as to why such provisions have not been followed. Again, when taking steps to engage with NHSPS or your landlord in any way, there are a couple of really important questions that practices can put to NHSPS to establish the basis for what they are actually being charged for. Some thought should always be given to the terms of the lease, again, and how it differs from the charging policy. And then any differences between the charging policy and the lease ought to be outlined to NHSPS. You might then put it to NHSPS and ask them under which terms of the lease they are basing their service charges on. Again, and it's always open to a practice to ask the asset manager themselves if they have reviewed the terms of their lease, the terms of the lease between the practice, and if so, what their conclusion to that was. Incidentally, the practices should locate all historic documents that it can and assess what was agreed with the PCT or any other predecessor landlord regarding those service charges. It's really important if they're available to discuss with or to the extent that they're able to provide any colour and to speak to any partners or staff who were at the practice at the time of the predecessor landlord, be it PCT or otherwise, especially at the time when the practice took occupation. Once all of this has been collated, we again encourage the practices to put their position to NHSPS and invite NHSPS to confirm if it agrees with their position, or in the alternative, provide a counter position. In this regard, it's always advisable that practices consider obtaining legal advice on the basis of its occupation. In this regard, again, and when dealing with NHSPS, it's often important to ask what historic evidence they possess, and if they can, and they should provide copies of those documents. And then finally, just in terms of specific charges that have been raised in respect of specific services, the practice can always ask that copies of all backing documents and invoices for the charges demanded are provided. You can also raise historic issues in respect of the quality of service, or, as we have previously encountered, sometimes services that just haven't been provided at all. You can similarly ask what basis they have apportioned and centralised their costs, and also ask them to confirm if they have removed any charges that they simply cannot evidence properly. There's many instances where their practices are not being provided with backing documents and may simply just be referred to a specific ledger entry. Just on the basis of service charges, it was found in 2 of the cases on the reading of the lease that there was no positive obligation on NHSPS to provide services at all. And as a result of this, the practices in question could theoretically ask NHSPS to cease providing services and take on the obligation themselves. In this sense, practices might, if it's something that they think they would like to take on, might want to consider whether their agreement or lease with NHSPS includes a positive obligation to provide services, and if not, whether they want to take on that obligation themselves instead. And then finally, the question we get asked a lot is, what if we do have a lease book, but it has expired some time ago? And we've come across many instances where practices continue to occupy a premises long after the term of their written lease has expired. In instances such as this, it'll be really important to consider, again, I keep labouring this point, the wording of the practice's previous lease, as well as any correspondence in respect of your tenancy that has been exchanged with NHSPS during the term of your lease and then post expiry of the lease. Generally, it's not strictly necessary, as Claire said, to agree a written lease with NHSPS, and practices can operate under existing occupancy arrangements, which will be informed by both their previous lease and, depending on the amount of time that has elapsed since the end of their lease, the manner in which the practice and NHS has been engaging historically. However, it's important to note that there are some caveats to this. So firstly, if the lease did not have the benefit of statutory protection, that is, if it was contracted out of security of tenure, then the practice's occupation is likely to be more precarious and the landlord could take steps to take back possession. Alternatively, if the lease did have benefit of security of tenure, then the landlord may have power to initiate formal proceedings for lease renewal by requesting a lease by serving what's known as a Section 25 notice. Reverting back to what Claire said, there are benefits to signing a new lease, and in that there's opportunity for the practice to negotiate the terms of occupation. Also, entering into a new lease can provide clarity, and certainty, and help to avoid and resolve future disputes. Again, and I spoke about this briefly earlier. In this instance, again, we strongly encourage that practices seek independent legal advice when negotiating new leases, be it with NHSPS or otherwise. It's extremely important that practices should not be forced to sign a lease under duress, or on the basis of any pressure, or enter one that jeopardizes their existing legal protections and future sustainability. I'll pass it back over to Claire now.
So we thought it'd be useful to just end on some key takeaways from the case. So actually the first point is back to you, Kai, sorry.
Sorry, I'll just put my camera back on. Apologies. Yeah, so the number one key takeaway from me in terms of written leases, and you will have picked this up because I laboured the point, that just to review the terms of your lease and ensure that NHSPS or your landlord are both aware of the terms of your lease, and that they are using the terms of your lease for the basis of any service charges they're seeking to raise. It's clear from the evidence that was put before the court in the Valley View case, as well as instances we are seeing recently when advising GP practices across England and Wales, that NHSPS are still wrongly relying on the charging policy when in fact a lease is in place that ought to be taken precedence in terms of what they are basing service charges on. The judge found that NHSPS's default position was to charge by reference to the charging policy. So in that instance, it's always worth asking your asset manager or customer service contact that they have actually, as I said, noted your lease on the system, noted the terms of the lease, reviewed the terms to check that they can actually charge what they are charging for, and that any service charges they are raising are based on the lease. Following on from that, I suppose my second key takeaway would be, to request the backing documents, and raising any issues that you have with services that have been provided, in terms of the level of service, any disproportionate costs, and whether such services were actually received by the practice. I'll pass it over to Stephen now. I think.
Sorry, delayed my camera. Key takeaways. Quite a simple one for me, really. It's be proactive. Be proactive in terms of assessing what your legal position is in relation to your lease, whether that's written or unwritten, and engage with your landlord early on. But first of all, as I said earlier, when I was talking about unwritten leases, is to make inquiries internally in relation to what the position is legally for your practice by reference to evidence and documents, speaking to other partners or previous partners, and just establishing, if it's an unwritten lease, especially what the terms of that lease are by reference to the conduct and what the parties intended and agreed at the outset. As I said, be proactive, engage with the landlord, and put your case as to what you say on the legal footing is what services are payable and aren't payable and why. and try and reach a landing with your landlord in relation to what the parameters of the service charge provisions are, because ultimately that's going to save disputes going forward, and you'll be able to resolve your position if you have any arrears of service charges that have occurred due to the uncertainty in relation to the lease provisions. But being proactive and engaging, and that's is certainly a very prominent message that came across in the judgment in this case.
And just to, before I go through the other three, just pick up on some of the comments that we're getting through. I can see that there's probably a lot of frustrated people hearing the key takeaway is to be proactive and put your case forward, because I can see a number of people who are saying they've been doing that for up to 10 years, 7 years, and aren't getting anywhere. In that case, all we can really advise is to do what the judge said, which is to put your case forward based on the information that you've got, and invite your landlord, whether it's NHSPS or someone else, to come back to you, to put their case back to you, and to actually engage in that conversation. It might be, I appreciate it's very frustrating to be hitting a kind of a wall and not getting anything back from them, but at least then you have done what the judge said, you have put in place your position, and then the ball is back in the court of your landlord to set out what their position is. So obviously what we're advising is best case scenario. We're well aware that a lot of your attempts and our attempts to engage do get ignored, but ultimately all you can do is follow what the judge advised. So the next one is to flag these aren't test cases, and I think it's important to remember that, but it's also important to remember, as Stephen explained, they are useful indications of how a court would deal with the different scenarios that we had. The 5 practices were in very different positions, especially with unwritten tenancies, where there isn't a lot of case law on what will be, whether service charges will be implied. In giving the judgment, the judge said whilst he expressed the hope that this judgment will assist the defendant, NHSPS, and other GP practices in resolving disputes over service charges without the need for expensive litigation, he would be wary of classifying them as test cases, as the lengthy judgment demonstrates, and as he'd already said in the judgment, the resolution of a service charge dispute in any particular case essentially depends on the evidence of arguments in that case. We've seen letters from NHSPS, and I'm sure you would have received them, which were sent out, from what we have seen, that are the same being sent out, that refer to parts of the judgment kind of en masse. They don't differentiate between the different ones. That's kind of, as I say, there are helpful parts in the judgment, and I can see why that approach would be taken, but ultimately it will come down to the specific facts. So if you've just been sent a letter that's very, very generic, but you think my case is very different here, and they've not set out to me my basis of occupation, then you absolutely can go back to them and say those weren't test cases, and whilst you might have an unwritten tenancy, it doesn't necessarily go hand in hand. You are going to have to pay the reasonable cost of the services they've provided. It is going to come down to exactly what your position is and what the facts of your case. They can't blanket rely on that judgment to say that you owe money just because you have an unwritten tenancy, and they must look at the circumstances individually. So it's worth continuing to put your case forward. The other key takeaway is the quantum point. So as I explained, there was kind of 2 reductions in the charges for those 5 practices. The first one when they had to redo their claim because they couldn't find evidence for all of them, and the second one being in the settlement. So, and in questioning, the CFO, the Chief Financial Officer, admitted there were instances of charging by mistake, overcharging. We've all probably seen the example of the lift in the premises that doesn't have a lift, which seems funny, but that isn't an isolated example. There are other times where charges have gone on to the wrong practice, whether it's because the same name or because they think a service has been provided. So, and we know that the record keeping was not great in the earlier years. So it's always worth pushing back, especially if you see things that you just know you haven't had. And asking for those backing documents. It might not be that you get the entirety of the information, but having something to just explain to you in further detail what is it that's said to have been provided, especially if you're seeing big reactive charges, or they're trying to say they've done large works. The final one is management fees, and I can see someone's asked a question about this. These were introduced by NHSPS in 2016-17. They were raised to recover their own internal costs of managing the provision of services to the properties in its estate. It's not a unique thing to NHSPS. It's certainly something that you do see in a commercial landlord and tenant scenario, especially where a landlord has a big estate, or they've employed a property management company. But I think the reason here it was seen as such a big thing is because that wasn't being done historically, and you certainly wouldn't have seen it even if it was being done. You weren't being charged for that management of the estate. That was something that either didn't get recharged or was just borne in the cost of the PCT. In the 5 claims, NHSPS actually removed the management fees pre-2007-18. So they took a chunk of those out because they felt that the method by which they were calculating them prior to those years wasn't clear, it wasn't capable of being validated. So removed them when they did that exercise of repleading. We don't know if they've mirrored that approach across the country, but if you're still in dispute of arrears back to 2016 or back to when NHSPS were incorporated, it's worth asking them if they have, and asking them to confirm the basis that they're charging you management fees, because it may well be that they decide to take that approach across the country because they'll realise that they can't maintain that. In these cases, the judge did rule that NHSPS can charge some management costs in principle. So in the unwritten ones, it was seen as a reasonable cost of providing reasonable services. In the written ones, it came within the definition of the service charge. But again, it is going to come down to the specific lease, the specific tenancy, and whether or not that's allowed to be in there. And even if they're chargeable in theory, if that management cost is too distant, or it can't be validated, it can't be aligned to an actual service that's been provided, it may not be recoverable, even if the TC allows them to. That doesn't mean they can just blanket apply whatever. They'll need to show what that's been applied to, what service was provided, and what that management cost was. So that's the end of what we had. So then it's on to questions. I've noted down just a couple, and then we'll see if we've got time for any others. I can see there's been a couple of questions around where you've got a superior landlord, and so you've got that freehold, someone who owns the property, then you've got NHSPS, and then the practice, and some comments in there around the lack of information being passed through. So you're just getting an invoice that's essentially what they've been charged, but nothing to back it. And the comments being that when you've asked for further information, they say, well, superior landlord didn't provide it to me, which potentially I imagine is true, but that doesn't mean that's the end of the line for that. Their lease with their superior landlord will likely have provisions in it around what should be provided when they're demanding charges. It might be that NHSPS or whoever it is just simply not asking for the information. They're just logging the invoice and charging it back out to you. So they should be asking those questions. It may even be that there is a provision in your lease with NHSPS or whoever your landlord is that actually says they have to be asking for those, or they have to enforce the terms of the head lease, which means they should be asking for further information. So it's worth going back to checking your lease if you've got a written lease, and also asking them to check their lease to see what kind of information they should have. If they're blindly paying it, that's their problem, but they should, you still have that opportunity to argue with it. I can see as well as a number of other comments around kind of specific charges, in particular those high, to say, roof replacement, boilers are another one, because they're obviously, that's something that when that breaks, that's a lot of money, and whether or not it's fair for the practice to be paying them, or whether it's legal. If you've got a written lease, that will set out quite clearly what kind of things are within a service charge and what things are excluded. Sometimes those kind of things are excluded if it's inherent defect, or it may even be that it's just excluded outright, anything to do with the fabric or the heating services. If it's unwritten, again, unfortunately, it's going to be more difficult. But there are arguments that can be raised, especially if you're looking to negotiate a new lease. It can be a bargaining point of, as one of the comments says, doing that, repairing a roof, repairing a boiler, that increases the value of the landlord's asset. They're going to have to do it anyway to get another tenant in if you say, well, I'll leave then, and it's increasing their asset. Yes, it provides you with heating, it provides a service, but ultimately it is an expenditure they'd have to do whether there was a tenant in there or not. So it's worth trying to negotiate that with them. And again, that does come down to another point on where it can be useful to have a written lease in place, because you would have the opportunity to negotiate with your landlord whether or not that's something that would be excluded going forward. And if they say no, then at least you know whether to enter into that lease or whether to continue to have those debates. And then just picking up on the point again about a number of comments about kind of being at gridlock with NHSPS. So can see some comments, and we're aware of this, of NHSPS saying they're not going to enter into a lease without historic debt being paid off. So they kind of want both things to be sorted at once. It's not surprising. It is a bit disappointing. I can see the benefit to resolving both at the same time, and it could be that you can use that to negotiate the terms of the lease if you're agreeing to pay a certain amount. But if you are at that gridlock, it's better to try and resolve one and to keep pushing to try and resolve one. If you're really wanting to resolve that historic debt, or to have some agreement there so that you know what has to be paid historically, or to have it written off, then you can push for that. Or if you really want a lease going forward, you can push for that. And it may well be that as you start to negotiate the terms of the lease going forward, you get to a point where the historic situation can be resolved, because if you know what you're agreeing to going forward, that's a basis of being able to look back. But it's also a way of saying, look, we're going to have this going forward. We're going to, we know the terms of this. We're not going to get into this dispute again. So let's just agree 50%, let's agree whatever. As I say, all we can do is continue to advise you to put your case forward, even if you're being met with silence. It's still making sure you're putting yourself in the best position for if you do end up in a claim situation. I don't know if there's any other questions you want to pick up on. I can see someone's asked if you can access the full judgment. Yes, it is very technical, it's very factual, it's very long. But if you go on a website called Bailey, you can search Valley View and it will come up and you can see it. I can't remember how many pages it is in total, it is very long. But it might be that if you think you've got a situation similar to one of these 5, it's worth having a look at that, so that you can kind of see whether there's any similarities in there, to see if there's anything else. So I can see, and this is something that comes up a lot, which is the landlord obliged to provide a breakdown of service charges rather than demanding a lump sum? Again, it depends on if it's written or unwritten. In a written lease, in an ideal world, a tenant will have a service charge provision that does set out that a landlord should be providing them with a breakdown of what they're charging for. And specifics around that, around whether, we've seen, ideally you would have a provision that says invoices should be provided, backing invoices, and that payments should only be made when they're there. In an unwritten one, it is more difficult because you'd have to show that there is an implied term or an agreement historically that service charges would only be payable upon receipt of a service charge account or backing information or something signed off by an accountant or a surveyor, for example. So it is harder to argue that. The way to look at it, though, is if you were to just refuse to pay them and your landlord had to pursue you in court, they would have to prove the cost of that. It may not be line by line every penny, but they would have to show what's within that lump sum, especially in an unwritten tenancy, and therefore they'd have to have that information to enforce it against the tenant anyway. So really they should be providing that voluntarily, and they should understand why you're asking for it. It's a lot of money and you shouldn't just be handing that over without knowing the background to it. Oh, yeah, sorry. So we covered at the beginning very briefly around building insurance and whether that should be covered by a landlord or tenant. So you can see it's been asked again. So again, that it will come down to the terms of the tenancy. I know it's something that's put in as standard with NHSPS that is recharged, and there can be some confusion around what that covers, because I know practices will quite often have their own insurance, which is slightly different to the building insurance. In a general commercial landlord and tenant world, quite often that is something that a tenant will pay, or at least pay a proportion of, depending on how much of the premises they are occupying. But it is, again, it's an item up for dispute. So if you have a written lease and it doesn't mention it, and you don't think it comes within the scope of what can be recharged, then you can dispute it. If you've got an unwritten tenancy and you've never paid it before, and you've got evidence of never paying it before, but the landlord procuring that insurance, then you can try and argue that it's not something that should be payable by the practice. Just checking if there's anything else. Anything that we haven't covered, we'll get a kind of spreadsheet of all the questions in here, so we can reach out, and you'll see on the screen our contact details. So if you have a specific scenario you want to discuss with us, then please do send us an email. I think that's everything that can be covered now without getting into too much specifics. So thanks for attending. As I say, our contact details are on the screen. So if you want to reach out to us, then please do pop us an email. Thank you.